Okay. So now let's start the program. The topic on which Bodhi is going to speak is a topic which has been talked about, discussed for a long period of time. And, if you look at just the constitutional order, scheduled tribe order, or constitution scheduled tribe amendment order, you can find that at different point of time, so many groups and communities have been added. And there's still demand that has been going on. And the recent case in Manipur is, again, an important example. Given that kind of a context, and there's a lot of issues involved, it has not been systematically explored. And I think Bodhi, in fact, tries to do that. And I thought that he should speak around 45 minutes, but I think his lecture is a little longer. So it will go a little more than 45 minutes. It's up to him. And once his presentation is over, we will open it for your discussions, comments. It would be good if you put your questions in chat box so that we can take this up. And question will be maybe 2 or 3 or 4 questions. First will be addressed, then second lot we can do it rather than questions and answers. So that's the way in which we can economize our time. So I don't really want to go much into it because it's a lecture which will take time. And therefore, I invite Bodhi to begin his presentation.
Okay, so thank you so much, Professor Khakha. Kind of creating this opportunity for us to meet as a tribal intellectual collective to discuss these issues that concerns current debates taking place within the country and even among tribal communities itself. I have framed my topic in such a manner as to kind of provide some kind of a historical glimpse of these issues. Titling my presentation around the idea of becoming a scheduled tribe in India, there are 2-3 things that I'm looking at. One is the history and then the legal processes that involves from a historical point of view. My presentation is broken up into 4 key components. The first component basically is an attempt to trace the genesis and the history of this idea called the scheduled tribe lists. There's a lot of debate at this arising, especially out of the 1950 constitutional order. Who exactly is in the list? Who is not in the list? So what I will try to do in this component of my presentation is to try to trace the history of this list and to kind of at least kind of share with everybody here who is part of this gathering today where we are as regards the constitutional order 1950 and where the list is as of today, 2023. The second part of my presentation is an attempt to kind of trace the evolution of these things called the criterias. When did these criterias come? How did they get formulated? And there's a lot of debate that is taking place about these criteria. So there's a need of clarification, but I will attempt to historicize it and provide a historical glimpse again about the evolution and the formulation of these criteria that we are talking about. The third part of my presentation concerns the of the modalities of procedures and process involved in demands coming from various communities in the countries of how to become a scheduled tribe. And also it kind of explains some of the things that have happened over a period of time in order to kind of, again, to kind of have an understanding about what has been the debates about modalities. And the last part of my presentation basically is just to kind of refer to some key judgments made by the Supreme Court of India as regards both the procedure and partly a little bit about the framework of the tribes, but much more with a stress on the procedures and processes concerning the demands for scheduled tribe status. So first, let me begin with the first component of my presentation, which is basically to do with tracing the lists. Now, for anybody who has gone a little bit deep into trying to understand how did this list came about, the scheduled tribe list, how did communities of various types and various habitats and various regions and territory, how did they basically get into this list that was identified in 1950? Now, for anybody who does that, you will have to go back to something called the Government of India Provincial Legislative Assemblies Order 1936. Now, this order is a very interesting order because it is to do with legislative assemblies. It is basically to identify assemblies to participate post the 1935 Government of India Act. So, in this list, basically what has happened is that it has identified a certain communities within certain provinces, okay, and declared in the 30th of April 1936. It identifies Madras, as you can see in the screen. Madras, 45 communities were identified, and then Bombay 24, Bihar 33 plus 8, Central Province 36, Assam 16, and Orissa 20 plus 2 plus 6. Now, this list is very important because of two things. One is because it was for the first time that the Government of India, under the 35 Act, declared a certain list of identities and communities in India, part of provinces. And the second thing is the category that was used to identify them, the backward tribes, as you can see in the right side of your screen. Now, after this list, it is only after this list comes the Constitution of India. And with the Constitution of India, list 1950, declared on 6 September 1950, we have what we call the Constitution Scheduled Tribes Order 1950. Now, as you all know, this is what is generally called the principal list, okay, the principal document, the principal constitutional order. In this Constitution Scheduled Tribe Order 1950, the Government of India identified 14 states: Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, West Bengal, Hyderabad, Madhya Pradesh, Madhya Bharat, Mysore, Rajasthan, Saurashtra, and Travancore and Cochin. And in this list, you have 212 communities listed as scheduled tribes. Now, it is this list that all of us refer to when we talk about scheduled tribes in the country. And it's in this list that either you will find your name either within the scheduled tribe or you will not find your name within the scheduled tribe framework. Now, after 1950, there was a little bit of it's called the Constitution Scheduled Tribe Part C States Order 1951. Now, the 1950 list was mostly a state list. We didn't have what you generally call the Part C states. It was basically the Part A and Part B states. So in 1951, the government, Ministry of Law, brought out an order for Part C states. And in the Part C states, there were 8 states that were identified as Part C. In Ajmer, there was 1 community identified as scheduled tribe. In Bhopal, 7. In Kurg, 6. In Himachal Pradesh, 1. In Kutch, 5. In Manipur, 3. In Tripura, 18. And in Vindhya Pradesh, 14 communities were identified as scheduled tribes. Now, there was another order in 1951 that was brought in. This is to do with union territories, very similar to the Part C states. And this is called the Constitution Scheduled Tribes Union Territories Order 1951, in which Lakshadweep 1 and Daman and Diu 5 communities were identified as scheduled tribes. Now, after the 1951 orders that came in, and let me just use the word Principal Act of 1950, the first real change that took place of a kind that is a little bit more fundamental is the year 1956. In the year 1956, the government brought out the Scheduled Castes and Scheduled Tribes Order Amendment Act 1956. Okay, this is Act number 63 of 1956. In this act, which was called the Scheduled Castes and Scheduled Tribes Order Amendment Act 1956, it was an act that came after something called the Kaka Kalerkar Commission Report. An amendment to the list was enacted on 25th September, following which, on the 29th of October, a modification order was published about the names of communities that were scheduled as tribes. So after this amendment, a modification order that came from the government in 1956, dated 29th October. In this particular order, for the first time, you begin to see a little bit more of an expansion of the tribal communities. And you see Andhra Pradesh, 2 plus 22 plus 7 plus 3. You see Assam, 14 plus 12 plus 9. You see Bihar, 29 plus 1. You see Bombay, 19 plus 1 plus 1 plus 1 plus 1 plus 1 plus 32, 7, 1, 3, 1, 5. Kerala, 3 plus 16, 17, 1, 1. Madhya Pradesh, 3 plus 1 plus 32 plus 16 plus 9 plus 6. Madras, 2, 20, 1, 1, 1, 17. Mysore, 9, 19, 5, 22, 1, 1, 6. Haryana, 62. Punjab, 3. Rajasthan, 6, 2, 19, 3. And West Bengal, 7, 1, 11, 22. Now, it might occur to you, why did I put these plus in between these numbers? Now, the reason that I put these plus within these numbers, as you can see in your screen, is because of the fact that this Scheduled Caste, Scheduled Tribes List Modification Order 1956 held on to a principle called the identification of Scheduled Tribe by territory, the identification by Scheduled Tribe by districts, which means if you see Andhra Pradesh 22273, 2 were identified in a certain district, 22 in another district, 7 and 3 in another type of district. If you see Assam, 14, 12, 9, this 14 was identified for a particular district within the 6th schedule area. 12 was identified of those tribal communities outside the 6th schedule area. And the 9 were identified as tribal communities in the plains area. So these plus is basically a demarcation of tribes and the identification of tribes within so-called specified area or within the particular state. Now, after the 1956 order, the next one, which I think is critical for us to understand, is something called the Scheduled Castes and Scheduled Tribes List Modification Order 1976. Now, one must know a little bit about this. The reason that this particular order came in 1976, one of which, the primary reason being the so-called reworking of the delimitation process as regards the states within the Indian Union. And because of that, in the delimitation, which generally happens 30 years after every 30 years, there was something called the removal of area restriction in terms of Scheduled Caste and Scheduled Tribe Amendment Act 1976. And from this particular act was developed the Scheduled Caste and Scheduled Tribe List Modification Order 1976. Now, what is significant is that while 1956 held on to identifying Scheduled Tribe within districts and within territories, the 1976 Act removed the area restriction, and now tribes were identified not by district, but not by territory, but across the state. So Andhra Pradesh now had 33. Interestingly, Assam is one of the states in which area restriction was partially removed. So initially, Assam, you will see, it had 3 areas distinctly identified for habitats of Scheduled Tribe. But in the 1976, it had only 2, the hill tribes and the plain tribes. That's why I've written there 14 plus 9. Bihar removed the area restriction. All the tribes identified in Bihar in 1956, in 1950, 56. By 1976, it was removed and 30 tribes were identified in the state of Bihar. In Gujarat, 29, Himachal, 8, Karnataka, 49, Kerala, 35, Madhya Pradesh, 46, Maharashtra, 47, Manipur, 29, Meghalaya, 14, Orissa, 62, Rajasthan, 12, Tamil Nadu, 36, Tripura, 19, West Bengal, 38, and a special act for the Andaman and Nicobar Islands, which identified 6 communities as scheduled tribes. Now, after this act, I think the only other major amendment that has basically taken is in the year 2002. It is called the Scheduled Castes and Scheduled Tribes Order Amendment Act 2002. Now, if you go into the details of this Amendment Act, you will find that there was a lot of so-called correction of spellings and names of community. There was an addition to the sub-tribe and the sub-sub-tribe within a particular entry of the list. And also you will see that new entries were added into the scheduled tribe list within a particular state. So this the 2002 Amendment Act was not very fundamental as compared to 1950, especially 1956 and 50 and 76, but it was also a major amendment taken by the government in order to kind of engage with this scheduled tribe list Constitutional Order 1950. Now, if you were to go into the details of the kind of amendments and modifications and orders that the government has brought about from 1950 to 2022, okay, you will see nearly about 23 of these. It began with the Constitutional Order of 1950. Then you see the Constitutional Order Part C states 1951. I've spoken about this. Then you have the Scheduled Caste Scheduled Tribe Order Amendment Act 1956, which came under the Backward Classes Commission or the Kaka Kalerkar Commission. I will speak about this a bit later. Then you see the Scheduled Caste Scheduled Tribe List Modification Order, which is Organization Commission. After this, there was a lot of changes that were brought into the list of Scheduled Caste and Scheduled Tribe. Then you see the Scheduled Caste Scheduled Tribe Orders Amendment Act 1976. And as I've explained to you, it was basically a readjustment and representation of parliamentary and assembly constituencies within the Indian state. Then you see the Constitution Order Scheduled Tribe of 1987. This is basically directed to Meghalaya and Assam. Then the Constitution Scheduled Tribe Order Amendment Act 1991 to do with Jammu and Kashmir. The Constitution Scheduled Tribe Order Second Amendment Order 1991 to do with Karnataka. Then the Amendment Act of 2002, which is across the states, which I've also mentioned just prior to these few slides. Then there was a very interesting act, a very one called the ST Scheduled Tribe Ousties of Madhya Pradesh and Maharashtra displaced by the Sardar Sarovar project in Narmada Valley and settled in Gujarat 2002. There was a little bit of a shift of the names and of tribal communities that inhabited some of these regions, and as they were moved and rehabilitated in other places and other states. Then you had the Amendment Act of 2006 to do with Bihar, the Amendment Act 2008 to do with Arunachal Pradesh, then Amendment Act 2008 again to do with Lakshadweep, Amendment Act 2001 Manipur, Arunachal Pradesh, the Amendment Act of 2012 Karnataka, the Amendment Act of 2013 Kerala and Chhattisgarh, the Amendment Act of 2020 Karnataka, the Amendment Act of 2021 Arunachal Pradesh, the Amendment Act 2022 to do with Tripura, then followed the Amendment Act 2022 with Jharkhand, the another 22 Act Uttar Pradesh, Tamil Nadu, and finally Kerala. So if you look at some of these, what has basically, if the question arises about what is this tribal list that people are talking about? What is this constitutional order in which certain communities have been identified as scheduled tribes and while others are not? You will have to go to these lists. And this list, the Principal Act is 1950, but there have been a lot of amendments, fundamental to which is 1956. The second one is 1976. The third one is 2002. And after that, many, many amendments have taken forth till 2022. Now, I will stop here for this part or the first component of my presentation. Now, let me go to the second part of my presentation, which I think is also very critical, at least in the light of the kind of debates happening right now. This is to do with the frame. I'm trying here to trace the evolution and development of something called the criteria. And these criteria are currently being debated. I read newspapers, I read many of the articles being written by fellow academics. I looked at many videos that are put up in YouTube regarding the debate. Everybody is debating the criteria. Who can be a scheduled tribe? Why are some communities not allowed to become a scheduled tribe, while some communities are allowed to be scheduled tribe? What are these criteria that are there? Now, anybody who wants to understand how these criteria were developed will have to go back to something called the Scheduled Districts Act 1874. Now, it is for the first time that the government of India basically identified something called scheduled districts under the Scheduled District Act 1874. So many districts across the country were identified as scheduled districts. And there was not immediately an identification of tribal communities, but the tribal communities were heavily inhabiting these particular districts across the country. Okay. After the Scheduled District Act of 1874, you have the Government of India Act 1919. Now, what is interesting here is it's for the first time that some of the scheduled districts were identified as backward tracts. So if you want to understand this idea called the criteria of identifying who is tribe and who is not, you will have to go back to this concept of the identification of community by the habitat and territory around the scheduled district and later the backward tracts in 1999. Now, as you all know, the census of 1931 also brought one interesting concept called the primitive tribes. Now, the census is another debate altogether, because in the census, what basically happened was, in trying to identify many of these communities that were not part and parcel of the mainstream society, a lot of concepts were used. For instance, in 1891, the concept of people having, tribal form of religion was used to identify these communities. Then in 1901, till 1911, the concept of tribal animism was used. Then in 1921, you had the hill and forest tribes. Then in 1931, you have the primitive tribes. Then 1941, you have tribes. And then finally, as you move on, you have another category that came with the government of India. So this point that I'm trying to make here, that the census identified the tribes, the primitive tribes, is critical because of many reasons you will see as we the criteria and the evolution of these criteria. But please note, before I go to the Government of India Act 1935, that the tribes were not identified by communities in the initial process. They were identified as people inhabiting a particular geographical area, particular territory. So by the Government of India Act 1935, this particular community was identified, as I have shown you in the provincial order for the assemblies of 1936. Set of community inhabiting some of those provinces were identified as backward tribes. Now, this is very important to kind of understand, because it is for the first a group of people were identified and a category given in the constitutional order, in an order of the government, called the backward tribes. Now, what is very interesting to note is the 1874 Act and the 1995 Act are very linked to each other. Now, anybody who's interested in this will have to go, because the argument is that the 1874 Act applied throughout the country till it was basically replaced by the Government of India Act 1935. This is important to note, at least for people who are interested in academics, to try to understand the details of these processes. Now, so we are left with a category called backward tribes in 1935, and that was for the first time that a list was presented. Then the Constitution of India 1950, Article 366(25), makes one kind of an understanding of who these communities are. Now, interestingly, the Constitution of India did not identify or define who these communities are. Instead, the concept of scheduled tribe was such tribes or tribal communities or parts of or groups within such tribes or tribal communities as are deemed under the Article 342 to be scheduled tribe for the purpose of the Constitution. Now, what is Article 342? The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the tribe or tribal communities or parts of or groups within tribes or tribal communities, which shall, for the purposes of this Constitution, be deemed to be scheduled tribes in relation to that state or union territory, as the case may be. Now, you have here it becomes very clear that there was no real definition of who scheduled tribe are, but the lists of the 1950, as I mentioned to you, was actually sourced from the 1935 backward tribes that was as a category that was used to identify these communities. But it is clear that in the 1950, there was no real criteria of who is scheduled tribe. Although the list was taken from 1936, the only one who is scheduled tribe is one who is identified by the state to be a scheduled tribe. There was no real clear definition or criteria. However, if you go to the next, which is the first report of the Commissioner of the National Commission for SC and ST in 1952, an attempt was made by the Commissioner to basically try to ask the states, what do you think could be the criteria that should help us define who is scheduled tribe? And in the Commission report, you will see that the idea of the primitive way of living, habitation in remote and less easily accessible areas, nomadic habits, and love for drinks and dance was suggested by 14 states that were asked by the Commissioner to help identify what are the characteristics that we can use to identify the scheduled tribe community. Now, these have not become law at all, because as a matter of fact, tribes are only those that are identified as scheduled tribes by the state. However, the Backward Classes Commission, or generally the Kaka Kalerkar Commission report of 1953-55, that was basically constituted, began to look it was basically responsible to look at backward classes community, but another added responsibility was given to look into the SC/ST list also at the same time. So there was a chapter in this commission's report, and in this chapter, the commission, Kakarler Commission, noted the scheduled tribes can also be generally ascertained by the fact that they live apart in hills, and even where they live on the plains, they lead a separate, excluded existence and are not fully assimilated into the main body of people. Scheduled tribe may belong to any religion because of the kind of life led by them. This is what the Backward Classes Commission kind of noted. Now, the responsibility of the Backward Classes Commission in suggesting these kind of issues arose because of many, many reasons. And it is this commission report that led to, as I noted earlier, the amendment of the Scheduled Tribe and Scheduled Caste list of 1956. And with the coming of the States Reorganization Commission, then the modification order of 1956 basically came 1 month after the amendment that was brought about post the Kakarler Commission report. Now, till then, I think it went on in that particular manner, but it was the Dehbar Commission report on the Scheduled Areas and Scheduled Tribes Commission 1960-61. 60-61 means appointed in 1960 and submitted in 1961. This commission was basically looking at scheduled areas, not much about scheduled tribes, about scheduled areas. And it was more, if you read the commission's report, it's much more to do with development processes. But this commission added a very interesting kind of a element to this whole debate, because it identified what are these scheduled areas that were so fundamental to the development of the so-called scheduled tribes, the identification of scheduled tribes within the Indian state. Now, the Dehbar Commission identified the concept there should be a preponderance of tribals in the population. To identify a place as scheduled area, there must be a preponderance of tribals in the population. Area should be compact and of reasonable size, should be underdeveloped, and there should be a marked disparity in the economic standards of the people in the area as compared to those of their neighbors. So here you begin to realize that a certain kind of frame was coming into place. One was how exactly these tribes will be identified post the 1950 list. At the same time, the clear identification of the kind of areas that the tribal community kind of inhabit. And in defining these areas, and remember, when you are talking about areas, there is something of the 5th schedule, the 6th schedule. What village is in the 5th schedule? What village is outside the 5th schedule? Why should this village be brought into? Why should that village be brought outside the 5th? This was the debate regarding the Dehbar Commission identification of scheduled areas and scheduled tribes. Now, after this, there were many things that basically happened. And I think it's very important to note this, because just to kind of take you back a little bit, after 1950, there was a lot of debate that began to emerge. And this debate emerged from the creation of new states. In 1953, you had Andhra Pradesh. In 1954, you had Himachal. By 1960, you have the Bombay state was divided into 2 states. And with these divisions of creation of new states and the division of existing states, this list that was in existence in 1950 order started to become very complex. And the complexity gave rise to a lot of anomalies. Okay. And so this commission called the Lukur Commission was basically tasked. It was called the Advisory Committee on the List of Scheduled Caste and Scheduled Tribe, 1965. This commission was tasked to correct these anomalies. This commission was tasked in order to kind of somewhat also develop criteria who should be and who should not be tribes. So this is a very important commission. And in that commission in 1956 report, if you were to look, and I'll present the details of this commission a bit later, it noted like this, that to say that one is a scheduled tribe, the concept of the indication of primitive traits is number one. Then distinctive culture, geographical isolation, shyness of contact with community at large, backwardness, and one very important line which actually the local committee stated in its report. It reads like this: tribes whose members have by and large mixed up with the general population are not eligible to be in the list of scheduled tribes. So from the Lukur committee, you begin to realize a certain kind of criteria is emerging for the first time. But it's very important to understand that this commission was an advisory committee. Okay, it was advising the authorities that set up this commission to look into these criteria. But it is only in the 1969 report called the Chanda Committee report of the Joint Parliamentary Committee on the Scheduled Caste and Scheduled Tribe Order Amendment Bill 1967. Now, after Lokur, there was a bill that was proposed called the Scheduled Caste and Scheduled Tribes Order Amendment Bill 1967. It was debated in Parliament. It was proposed in Parliament, debated, and after that debate took place, a joint Parliament committee under Chanda was basically constituted. Now, interestingly, in this particular committee, there's a very interesting report. But although this committee in the initial pages did not mention Lokur directly, it actually was the real committee that established the criteria directed by Lokur and brought into what is understood called the criteria that are used till today by the government of India. So as a matter of debate, I will kind of discuss this a little bit later, but as a matter of just to clarify understanding, at least in the academic sense, a detailing of these processes, it was the Chanda committee that actually institutionalized the criteria. Although Lokur proposed it, but the Chanda was the one who disposed these criteria and made it part and parcel of the government of India process. Now, after the Chanda committee report, there's been not really much, but the criteria began to be actually, there was a lot of documents that I have observed on my own sand and also evidence that I have, which the government of India, especially Ministry of Home, began to write to states. And in writing letters to state regarding these idea of demanding who's scheduled tribe and who's scheduled tribe and complaints that were coming post the 1976 debate that took place, as I mentioned to you, about area restriction, letters were sent to the state in which these criteria of the Lokur and the Chanda committee was basically instituted and put in this GRs of the government. And every state was asked, use these criteria in order to verify what community is in and what community is not in, what certificate is the correct certificate, and what certificate is a false and fake certificate. Okay. Then later in the government of many other government GRs at around 1979, the government GR started being sent to many of these state authorities of the state. And again, the institutionalization process took place. And I've just written here, in seeking states' view on Scheduled Caste and Scheduled Tribes Order Amendment Bill 1978, for the first time, the Home Ministry kind of began to send letters to the state regarding these criteria. So if you were to look at this slide, the thing that you must kind of understand is that if you have to understand the criteria that were developed to identify scheduled tribes today, in which the debate is taking place, you must go back to the Scheduled Areas Act of 1874, because it is from the region and the place and the territory and the geography. It was not the tribe identified initially in the beginning. It was this idea of the region, of the territory that was used. As it evolved to backward tracts, and then the idea of backward tribes, and then this Constitution of India identifying the president with the power and the authority to identify who's scheduled tribe, then with the commissioner identifying from 14 states response about certain criteria to identify scheduled tribe, then the Backward Caste Commission, the Dehbar, Lokur, Chanda, and then the criteria of both the central government under the Ministry of Home and also the criteria that were developed by the state. So this is exactly a glimpse of how we can understand these processes a little bit. Now I want to detail three things, and these are major debates. Key things. One is, what exactly is there in the Constitution of India 1950? What exactly is there that basically gives indications of who is a scheduled tribe and who's not a scheduled tribe? Okay, it's not clearly stated, but I will kind of problematize it a little bit to give you a sense of what it is all about. Then I will also go a little bit to the Lokur Commission report and try to explain what actually happened during the period in which Lokur Commission was looking into these issues. And finally, I will talk about the criteria that the states are using across the country to identify who's scheduled tribe. And the last part is the government GR that basically I'll just share some kind of evidence that I have to kind of show you how these processes take place. Now, after all of this, the first thing that we must begin to discuss is this thing called the Indian Constitution 1950. Now, Article 342 reads like this. 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by public notification, specify the tribes or tribal communities, or parts of or groups within tribes or tribal communities, which shall, for the purposes of this Constitution, be deemed to be scheduled tribe in relation to that state for the union territory as the case may be. Clause 2 reads, Parliament may by law include in or exclude from the list of scheduled tribes specified in a notification issued under Clause 1 any tribe or tribal community or part of or group within any tribe or tribal community, but save as aforesaid in notification issued under the said clause shall not be varied by any subsequent notification. Now, the question that some of us are asking is that, what is the context and the source of this particular article? What is the context and the source? How did this article come about? Why is there no definition of tribe? What exactly was the debate that took place in developing this particular article? And these are very detailed debates. Now, to do this, we'll have to go to a debate between Jaipal Singh Munda and Babasaheb Dr. B.R. Ambedkar. Now, I will read this out because this is very important. Because in order to get a context of how Article 342 was developed, we have to understand this debate that took place in the Constituent Assembly. Now, on a particular day, Jaipal Singh asked the question, and he said many things, but I've just taken only that relevant portion, which is in the light of the debate that we are having, in the light of the discussion we are having right now. So Jaipal Singh, who represented the general but Adivasi component within the Bihar state, stated like this. But there are one or two things on which I would like Dr. Ambedkar to enlighten me. The first point on which I would like his clarification is in regards to the amendment which he has moved, amendment number 491, wherein he seeks to substitute the word aboriginal by the word scheduled. Sir, I am always at a disadvantage whenever anything affecting aboriginals has to be discussed at this stage, for the obvious reasons that the two reports of the subcommittee, tribal subcommittees, have not been fully discussed on the floor of this house. Not been able to obtain its collective viewpoint or arrive at a collective decision, as has been the case with all other articles. That is to say, articles which affect the non-tribals of our country. Take the question of this word tribal. As far as I know, neither of the subcommittees had gone into the work of the scheduling. Now, please note, these subcommittees are two. One was led by Bordoloi, another one was led by Thakkar, by A.V. Thakkar, looking at Northeast. And the Thakkar committee was basically looking at all of India, especially the central and all the other part of the country inhabited by tribal communities. So take the question of the word tribal. Jaipal Singh notes, as far as I know, neither of the subcommittees had gone into the work of scheduling. I know it for a fact that the subcommittee of which I was a member, Jaipal Singh was a member of the Thakkar committee that was looking at all of India, other than Assam. I was a member, did nothing of the sort. And in fact, bodily, the drafting committee has just put into the draft constitution whatever obtained in the Government of India Act, referring to 1936. Now, look at the lists. Now, my second point that I want to have clarified is whether the advisory councils of the regional councils, which are envisaged in the recommendation of the two subcommittees, will operate outside the so-called scheduled areas. If they do not, then I want to know from Dr. Ambedkar, what is going to happen to the Adivasis, who are in millions outside those scheduled areas? As far as I can understand, the language of the Constitution, the regional councils and the advisory councils are to advise the governor to participate, as it were, in the legislation of the state only in regard to the scheduled areas. Well, once it is accepted that the regional councils and the advisory councils may operate also outside the scheduled areas, then my point is met. Take the case of West Bengal. In West Bengal, according to what is proposed, there shall be no scheduled areas in West Bengal. In West Bengal, there are 16 lakhs of Adivasis. I want to know what is going to happen to them. There is no regional council. There will be no advisory council there. Who is going to advise the governor in regard to their welfare, in regard to whatever should be done or should not be done? What act may operate for them or against them? I think that is a point that has to be clarified. So Jaipal Singh was asking Babasaheb Ambedkar a very critical question of how this concept of scheduling came about. Why should you use the word scheduling? Why don't you just identify a category called Adivasi? Why don't you use the word Aboriginal and so on and so forth? Now, Dr. Ambedkar's response to Jaipal Singh on this particular question was, and I'll read it. Now, sir, my friend, Mr. Jaipal Singh, asked me a certain question about the Adivasis. I thought that that was a question which could have been very properly raised when we were discussing the fifth and the sixth schedule. But as he has raised and as he has asked me particularly to give him some explanation of the difficulties that he has found, I am dealing with the matter at this stage. The House will realize what is the position we have laid down in the draft constitution with regard to the Adivasis. We have two categories of areas, scheduled areas and tribal areas. The tribal areas are areas which relate only, while the scheduled areas are areas which are scattered in provinces other than Assam. They are really a different name for what we use in the Government of India Act 1935 as partially excluded areas. There is nothing beyond that. Now, the scheduled tribes live in both, that is, in the scheduled areas as well as in the tribal areas. And the difference between the position of the scheduled tribes in the scheduled areas and the scheduled tribes in the tribal areas is this. In the case of the scheduled tribes in the scheduled areas, they are governed by the provisions contained in paragraph 5 of the fifth schedule. According to that schedule, the ordinary law passed by Parliament or by the local legislature applies automatically unless the governor declares that the law or part of that law shall not apply. In the case of the scheduled tribes in the tribal areas, the position is a little bit different. There, the laws made by Parliament or the law made by the local legislature of Assam shall not apply unless the governor extends that law to the tribal areas. In the one case, it applies unless excluded, and in the other case, it does not apply unless extended. That is the position. The second point now that Babasaheb Ambedkar's response to Jaipal Singh is very important. Now, coming to the question of the scheduled tribes and as to why I substituted the word schedule for the word aboriginal, the explanation is this. As I said, the word scheduled tribe has a fixed meaning because it enumerates the tribes, as you will see in the two schedules. Well, the word Adivasi is generally a general term which has no specific legal deed, like the untouchables. It is a general term. Anybody may include anybody in the term untouchable. It has no definite legal connotation. That is why in the Government of India Act 1935, it was felt necessary to give the word untouchable some legal connotation. And the only way it was found feasible to do it was to enumerate the community in different parts and in different parts, which in different parts and in different parts and in different areas were regarded by the local people as satisfying the test of untouchability. The same question may arise with regards to the Adivasis. Who are Adivasis? Who are Adivasis? Dr. Ambedkar asks. And the question will be relevant because by this constitution, we are conferring certain privileges, certain rights to these Adivasis. In order that if the matter was taken to a court of law, there should be a precise definition as to who are these Adivasis. It was decided to invent, so to say, another category or term to be called scheduled tribes and to enumerate the Adivasis under that head. Now, my friend, Mr. Jaipal Singh, if you were to take the several communities which are now generally described as Adivasis and compare the communities which are listed under the head of their scheduled tribe, hardly a case where a community which is generally recognized as Adivasi is not included in the schedule. I think here and there a mistake might have occurred and a community which is not an Adivasi community may have been included. It may be that a community which is really an Adivasi community has not been included at all. But if there is a case where a community which has hitherto been treated as an Adivasi community is not included in the list of the scheduled tribes, we have added, as may be seen in the draft constitution, an amendment whereby it will be permissible for the local government by notification to add any particular community to the list of scheduled tribes which have not been so far included. I think, Dr. Ambedkar says, that ought to satisfy my friend Mr. Jaipal Singh. He asked me another question, and it was this. Supposing a member of a scheduled tribe living in a scheduled area or a member of a scheduled tribe living in a tribal area migrates to another part of the territory of India in the tribal area, will he be able to claim from the local government within whose jurisdiction he may be residing the same privileges which he would be entitled to when he is residing within the scheduled areas or within the tribal areas? It is a difficult question for me to answer. If that matter is agitated in quarters where a decision on a matter like this would lie, we would certainly be able to give some answer to the question in the form of some clause in this constitution. But so far, as the present constitution stands, a member of a scheduled tribe going outside the scheduled area would certainly not be entitled to carry with him the privileges that he is entitled to when he is residing in a scheduled area or a tribal area. So far as I can see, it will be practically impossible to enforce the provisions that apply to tribal areas or scheduled areas in areas other than those which are covered by them. Now, this is if you look at the proper document, it's page number 1024 to 1026. This very interesting debate discussion between Jaipal Singh and Babasaheb P.R. Ambedkar. And here you'll get a glimpse of how this kind of contextualization and also the formulation of an idea of a particular group scheduled tribe categories took place. So now it is from this kind of a debate, and there's much more, but I have brought in only that relevant portion where I think it's related to Article 342, but there's no much more to the debate. Now, Article 342, you will realize, as I've shown, if you look at the right side of the screen, the president may, with respect to a state, identify tribe or tribal communities to be identified as scheduled tribe. Article 342 has to be read in the light of two more articles. That is Article 340 and Article 341. We cannot read Article 340 in isolation. Now, what is the reason for this? Because the reason for this is that the Constitutional Assembly's conception of the scheduled tribe must be read in relation to Article 340, 341. All the three articles, 340, 341, 340, are a holistic frame that must be read together as envisaged by the Constitution makers. I've just noted this point. But one of the things that are very important to note here is read the lines properly. You see, in Article 341, it reads like this. The president may, with respect to any state or union territory, and where it is a state, after consultation with the governor, by public notification, specify the castes, races, or tribes, or parts of, or groups within castes, races, or tribes, which shall, for the purpose of this constitution, be deemed to be scheduled castes in relation to that state or union territory, as the case may be. Now, please note, as per this article, even if you are a caste, if you're a race or a tribe, you can still be identified as scheduled castes. And there is a very interesting debate, which I will show you as we move on. And this debate is regarding the fact that castes, races, or tribes, or part of or groups of caste, race, or tribe, can be identified as scheduled castes based on one criteria, the experience of untouchability. Any community in this country, no matter whether you're caste, whether you're a race, or whether you're a tribe, if you have experience untouchability, you will have to be brought in. There'll be a space created for you around this idea of scheduled caste. Okay, so there are many interesting examples for this. Like without mentioning the name of any community, there is a community, for instance, that state is one district. In that particular district, it has something called, it is identified as scheduled caste. Okay, in another district, it is identified as a nomadic tribe, and in another district and state is identified as a scheduled tribe. A single community, a single tribal community, in one particular district is a scheduled caste, another district is a nomadic tribe, another district, it is a scheduled tribe. Why so? Because in that earlier, the first district, in that particular tribe, people around have practiced untouchability against them. And because they've experienced untouchability as a tribe, they were identified as scheduled castes. In the other district, untouchability was not so much practiced, and they were a little bit independent, but they were basket weavers. They were basically, entrepreneurs of a particular kind. In that particular district, they identified as nomadic tribes. So had these, they were weaving basket at the same time of this nomadic characteristic. So they were identified as nomadic tribe. And in another state, district, the same community is identified as scheduled tribe because there they inhabit forests and they inhabit the hills. Now, as you know, the debate is generally that if there are many of us who have worked in these areas, if you ever travel to tribal areas, you will always realize that as you move from the plains to the hills, you know, you will have very less tribes. And as you move to the hills, you have more tribal communities. So the hills generally is one way of identifying. And in the hills, they're very consolidated, geographically bounded areas in which tribal communities inhabit. The more you come down, the lesser you have tribes, and they are sparsely all over the place in that particular sense. So this is important. But why is it important? It is important because in the light of 341, 342, on the other hand, reads like this. The president may, or president or state or union territory, with respect to any union territory or state, after consultation with the governor, by public notification, specify that tribes or tribal communities or parts of or groups within tribes or tribal communities, which shall be for the purpose of this constitution be deemed to be scheduled tribe. What is the difference between Article 341 and 42? In 341, it doesn't matter race, tribe, and a caste. If you have experience untouchability, you basically will fall under the scheduled caste category. But for 342, Article 340, you only have to be a tribe and no one else. And probably, as we discuss further, I will show to you how exactly a tribe is identified. Actually, a tribe is identified, at least in this context, as you can see, only tribes or tribal communities. No mention about caste. Here, there's no mention about race. You have to be only a tribe for you to be identified as scheduled tribe. On 341, you can be a caste, race, or tribe to be identified as scheduled caste. Now, this also has to be read in another article called 340. Now, the Article 340 is generally identified communities which is under the OBCs, the other backward classes. Article 340, I'll just read a little bit. The president may by order appoint a commission consisting of such persons as he thinks fit to investigate the conditions of socially and educationally backward classes within the territory of India and the difficulties under which they labor, and to make recommendations as to the step that should be taken by the union or the state to remove such difficulties and to improve their condition, and as to the grants that should be made for the purpose by the union or state, and the conditions subject to which such grants should be made. And the order appointing such a commission shall define the procedure to be followed by the commission. Now, you see three articles. Article 340, the other backward classes, the OBCs, always identified around socially and educationally backward classes. And as you know, these backward classes are identified especially around the intermediary caste within the caste structure. In Article 341, caste, race, or tribe. If you have experienced untouchability, you will be identified as scheduled caste. Article number 342, clear. Only if you're a tribe and no relation with anything else, especially in caste society or with other societies, and the genesis of which you are a tribe, only that particular group will be identified as scheduled tribe. Now, I read out Jaipal Singh's discussion with Baba Saheb in the Constituent Assembly debates, and I've begun now to problematize a little bit about trying to understand 342. And I will tell you this. The only article within 340, 41, and 42 that has a definition of what community should be identified within a particular category identified by the state are the scheduled castes. Not even the OBCs, not even the tribes have a definition. The real definition lies with the constitution identifying who is scheduled caste. And anybody who is not scheduled caste and have different kind of characteristics and have different kind of ways of life and different kinds of criteria, they are identified as tribes. And the intermediary caste identified around the notion of class was brought into 340 under the category called OBCs. Now, this is very important to note because many people make a mistake. There are many communities that are demanding to be scheduled tribe, but they're basically a caste. So there are many castes, especially intermediary castes within the OBCs that demand scheduled tribe status. And there are many, even some races, for instance, that are demanding scheduled tribe status. But the clarity that the Constitution gives is this. Only if you can actually identify yourself as a tribe that allows you to become a scheduled tribe. If you're a caste, race, or tribe, you either go into OBC if you're intermediary, or if you have experienced untouchability, you will fall under Article 341. Now, After this, let me go to the Lokur Committee in 1965. As I have stated, I think this is very important to kind of discuss. Now, the Lokur Committee, which is an advisory committee looking at trying to identify, first to rectify anomalies that have been generated after that has occurred within the scheduled caste, scheduled tribe list, and also to help develop criteria to identify scheduled tribe, made certain points, and I've taken this directly from Lukur's report. Okay. Now I've marked if you look at the left side of the screen, there is a yellow kind of a highlight that I've given, and I'll read only that highlight. Lukur says like this: it is relevant to note that the Constitution also recognizes another section of the citizens as deserving of special care, namely the backward classes. This distinction ought therefore to be well kept on the one hand and the backward classes on the other. It will be observed that under the Article 341, not only castes and groups within castes, but also races or tribes and group with tribes that can be specified as scheduled castes. Under Article 342, Lokur noted, however, only tribes or tribal communities or groups within tribes or tribal communities have to be specified as scheduled tribes. I have explained, Lokur notes, depressed classes as castes. Now, depressed classes is a concept that existed prior to 1935. Many of the communities that experience untouchability in this country were identified as depressed castes. It is only in 1935 that they were called scheduled castes. Okay, so I have explained depressed castes as castes, contact with whom entails purification of the high caste Hindus. It is not intended that the term should have any reference to occupation as such, but to those castes which by reasons of their traditional position in the Hindu society are denied access to temples, for instance, or have to use separate wells, or are not allowed to sit inside a school house, but have to remain outside or suffer similar social disabilities. Now, in point number 8, Lukur notes, in the preamble to the questionnaire issued by the Backward Classes Commission in 1955, the Kalirkar Commission, the commission observed, in the matter of scheduled castes, the criterion is clear. Untouchability is the criterion, and it being peculiar to the Hindus, those Hindu castes that were regarded as untouchables by the society are included in that particular schedule. Non-Hindus cannot be included in this. Means non-Hindus cannot be included in Article 341. Now, go to the right side of the screen. This is what Lukur writes. In considering fresh proposals for inclusion in the list, that is the list, 1950 list, the primary list, the principal list of the scheduled tribe, it was noted that care was necessary in drawing up the schedule in order to ensure that communities which had been assimilated in the general population were not at this stage invested with an artificial distinctiveness as tribes, and that communities which might be regarded as tribes by reason of their social organization and general way of life, but which were really not primitive, should now not newly be treated as primitive. In point number 12, Lukur writes, and I have marked it in blue. In revising the list of scheduled tribes, we have looked for indications of primitive traits, distinctive culture, geographical isolation, shyness, contact with the community at large, and backwardness. We have considered that tribes whose members have by and large mixed up with the general population, or in other words, mainstream, are not eligible to be in the list of scheduled tribes. Okay, so actually, if you look at the Lukur way of conceiving the criteria or developing criteria, there are two sets of criteria I've mentioned you in the earlier part of my presentation. There are certain criteria starting with primitive traits, distinctive culture, geographical isolation, and so on, total backwardness. And also those communities that are tribal communities, but mainstream and have become part and parcel of the general population are not eligible to be in the list of scheduled tribes. Now, I just want to explain this much about the Lukur criteria. If you read the Lukur criteria and the Lukur report, these 5 criteria, actually, Lukur contributed only 3 criteria. That is distinctive culture, geographical isolation, and shyness of contact. The idea of primitive traits was taken from the 1931 census. And the idea and the 5th criteria of Lukur or backwardness was taken from the 1936 provincial order, which identified these communities as backward tribes. So 1931, primitive tribes, 1936, backward tribes. Lukur brought these two criteria together and added his own distinctive culture, geographical isolation, and shyness of contact with the community at large. So if you were to understand the Lukur criteria, if you read the details, this detail is already written, it's not something new, but you will begin to understand how these criteria were developed. Okay, what is the point here? A lot of historical processes was taken into consideration in identifying and the creating of these criteria to identify the scheduled tribe. Now, the second part is also very important. Clearly noted, if a tribal community has been assimilated, has been absorbed, has become part and parcel of the general population, okay, and the word assimilation is a very important word. Such communities are not eligible to be in the list of scheduled tribes. This is exactly how it was created by Lukur. Now, the last point, which I think is important just to note, although not directly related, is inclusion of communities. In view of our approach indicated in the preceding chapter, we have been strict in making new additions to the list, and I've included thereon afresh only a very limited number of castes and tribes, that is, in the scheduled caste and the scheduled tribe orders, after convincing ourselves that they fully satisfy the criteria and have in the past been somehow overlooked. So this is the debate regarding the Lukur Committee development of the criteria. And the Lukur Commission report is a very interesting report. I think one should read about this for any of us in the tribal collective who's interested to understand the nitty-gritty, and if you historicize this, you begin to see it very differently. Now, the third part, which I think is very important, is what is generally called another set of criteria. So you see the criteria that was developed by the Constitution of India that is embedded and embodied. What is the criteria? 342 can be read only in relation to or in the light of 341. Country that has a clear, definitive, and defined identity are the scheduled castes, and who are communities who have experienced untouchability. Now, communities who have not experienced untouchability, they will fall under the scheduled tribe. Communities who doesn't have a caste structure will fall under scheduled tribe. Communities who have not been assimilated fully will fall under scheduled tribe. Communities who are intermediate castes, it can be caste, race, or tribe, but socially and educationally backward, they can be identified as OBCs, the other backward classes. So the Constitution has this embodied in its structure. Look and framed it out, looking at the Commissioner's report, looking at Kaka Kalirkar's report, and then trying to frame in the light of being an advisory committee to develop these criteria and to correct anomalies. He developed these criteria taken right from 1931, primitive tribes, 1936, the backward tribes, and then the criteria was developed. Now, there's another set of criteria which people are talking about, and this basically is something that basically got somewhat consolidated or concretized after 1976, after the area restriction was removed, and a tribe was recognized no more by district but by a state. After the area restriction removed, there was a huge number of communities that had very similar names or had very similar ways of pronouncing the names, who began to actually avail the certificate of scheduled tribe from the state. And the Madhya Pradesh, Karnataka, and Maharashtra was the main area in which this debate took place. Okay, there were many people who did not belong to the scheduled tribe as listed in the list of 1950, basically availed scheduled tribe certificate. Now, these complaints were everywhere. Everybody was complaining about this. Even the scheduled tribe themselves were complaining about this, that many people are availing the list although they don't belong to the community. So what should we do? And in that sense, every state developed what is called the criteria to go and evaluate. Now, in some states, you can get a scheduled tribe certificate, but if you submit it, let's say for a job or submit to an educational institute, you also have to get a validity certificate. And the validity certificate has to be given by the scrutiny and verification committee of every state. Now, different states have different practices, but the general criteria, and this comes from a study that I've done with my colleagues over really in about 20 years, trying to understand the criteria at the level of the state. The criteria at the level of the constitution is different. Criteria at the level of the central government is different. But the criteria at the level of the state, when they go to verify and to provide something called validity certificate, are something like this. Now, I just put in the left side, you will see a letter from the Ministry of Home to the Chief Secretary of every state government and union territories, dated 29 June 1982. And this is to do with this. If you look down a little bit, point number 3, it reads like this. Number of bogus certificates detected during the last 2 years, 1980-81. Action taken against the erring officials. Who are these people who are issuing fake certificate of scheduled tribe? Under the relevant provision of the IPC, under the appropriate disciplinary rules applicable to them, action taken against person who obtains such bogus certificate under IPC. Details of the steps taken to curb such malpractices. So, by 1980s, people after the 1976 Act started availing, and a lot of fake certificates were there everywhere. The government Ministry of Home had sent this letter to the state secretaries, the chief secretary of every state and union territory. And verification committee began. Now, there's a certain set of verification criteria. The criteria used for verification or determining factors for identifying fake tribes and scheduled tribes are and these are not written down, but these are basically what is used, by many of these committees. The first one is bounded to a territory. A tribe is one who's bounded to a territory and a distinct tribal habitat. So if you go for your validity certificate, and if you say, I'm a scheduled tribe, the first question they will ask you, from what territory do you come from? Okay. And what particular habitat, distinct, it has to be a distinct tribal habitat. If you say, I have a tribal certificate, but I stay in another place altogether, you will be rejected. Second point, cultural and customary practice. The question they will ask you is, what is your culture? Explain to us what your culture is. What are the customary practices in your community? Then what are the gods and goddesses that you worship? Okay. Now, or even prior to part of your ancestral worship. Fourth part, clan and the clan totem. They will ask you, what is your clan totem? Do you have a totem or not for your clan? Then rituals in birth and death, including burial practices. Then food habits. Then one very critical point, dialect and language. Every tribe have their own dialect and language. Okay. It might change, it might be spoken differently. It might be used in a different manner, but they have to have that dialect and language. 8th point, the non-hierarchical structure in the tribe. The complete lack of social stratification except gender and age. Many of these committees who verify certificates, they will ask you, are you part of any particular, do you have a hierarchical structure in your community? Are you on top of someone? Are you below somebody else? Because tribal communities, strictly to a great extent, there is a class division, but the only stratification or social stratification is around the concept of gender and age. So this is another criteria used. Then the surnames. Surnames, most of the surnames will be asked. Now they will ask your surname. What does your surname come from? Now for tribes, surnames is generally connected to nature. It's not connected to occupation. So if a surname that is connected to occupation is, immediately you lose the validity of the certificate. But if your name is connected to nature, the way tribal communities have structured themselves, then the validity certificate will be further processed. And the last point used by the state verification committee is autonomous economic system, subsistence economy, not interdependent occupation like caste-based occupation. Caste communities have identified by their occupation within the caste structure. Tribals don't have the identification of occupations within their system. Many people can do anything they want. They can move up any different occupations and so on and so forth. What I have tried to do is to try to explain to you the whole gamut of how this, if you historicize the criteria, you begin to see so many kind of debates that taken place at various levels, at the level of the constitution, at the level of the Lukur committee that arose, at the level of state verification and validity certificate evaluation at the state level, and also the Ministry of Home and the Lok Sabha Secretariat. Many of these things now have got kind of brought in. Now, to kind of summarize what I said, there are 3 sets of criteria that has developed over a period of time, starting from 1950. Now, in the 1950s, as I explained to you a little bit earlier, criteria, although not clearly stated, is that a scheduled tribe, is not part of a caste or race or a tribe that has experienced untouchability. A tribe is a community that has not faced or experienced untouchability from other communities. That's the first criteria embodied. Why so? Because 341 article regarding scheduled caste is the primary, in my understanding, a primary act, a primary article in order to understand other communities. Without understanding 341, you cannot understand who's a scheduled tribe. You cannot understand also who's an OBC in that particular sense, Article 340. The second criteria embodied in the Constitution is not a tribe is not part of caste system or holding an occupation that is embodied and interdependent with other occupations within the set structure of caste. And the final one is a tribe is bounded to a territory, either a scheduled area or a tribal area. If you are outside of the scheduled area or you are outside of the tribal area, you are not a tribe. So the Constitution, when not by identifying tribal communities or what community is a tribe or not, it went by whether you are staying in the scheduled area. Even if you're a tribe of a community, but you are outside the scheduled area, you are not a tribe. You are not identified as a scheduled tribe. Even if you're a tribe from a tribal area, especially in Assam, in Arunachal, in Nagaland, in many other states in the Northeast, even if you're a tribe but you have stayed outside and you are born outside, you cannot get availed that the scheduled tribe status in that particular area. So from the Constitution, it is very clear what the criteria are. Unpack and unravel the details in the light of 340, 341, 342. The Lukur Committee, 1965, it is better to use the Chanda Committee criteria of 1969 actually, says indication of primitive traits, distinctive culture, geographical isolation, shyness of contact with community at large, and backwardness. And the criteria inserted by Lukur, which actually is a practice for many, many committees and many, many government institutions and government departments, is tribes whose members have by and large mixed up with the general population are not eligible to be in the list of scheduled tribes. Now, this is a very important, and the argument was simple, that if a tribe has been assimilated and has become mainstream, if you have become mainstream, you're part and parcel of the larger community, and in India, the part and parcel of the larger caste society, you are not a scheduled tribe anymore in that sense. Now, the verification committee is another set of criteria, but this is post 1977. Bounded to a territory, has land documents within a scheduled area and a distinct tribal habitat, cultural and customary practices that are distinct and unique only to that particular community, gods and goddesses, if not at least immediately, at least in practice, at least in memory, at least in history, clan and clan totem, rituals in birth, death, including burial practices, food habits, dialect and language, non-hierarchical structure, okay, not stratified other than gender or age, surnames connected to nature much more. It's not that, this is a very rigid way of looking at it, but connected, many tribes are connected to identifying themselves with nature rather than identifying themselves with occupation. An autonomous economic system, subsistence economy, not interdependent occupation like caste-based occupation. So these are the criteria. I think many people are making a mistake to identify only the criteria stated by Lukur. There are huge sets of criteria that are being debated. And these criteria are either embodied subtly or in a very nuanced manner, or they are openly stated like the Lukur. But at every level of the state government, the constitution, the central government, the state government, there are different sets of criteria. Now, if you ask me personally from my experience, it's a very complex idea, it's a very complex process. But this is what has evolved over a period of time. Now, I will stop here. About what I've just kind of noted, which is the second part of my presentation regarding tracing the evolution of criteria. The first part was to trace the list, how did it develop? The second part of my presentation is tracing the evolution of these criteria. Now, the third part, and I think is very important before I go to the third part of my presentation, which is to do with the procedures and the process. Okay, what is the procedure? Someone, for instance, is a community, and it says that, I want to demand to be a scheduled tribe as per the Government of India and the Constitution that allows me to be one. What do I do? What should I go? What is the process? Now, the procedure and process, the source of the current procedure and process of how to become a scheduled tribe has to be noted in the Constituent Assembly debate, which was spoken by Dr. B.R. Ambedkar in relation to Article 341 and 342 in the Constituent Assembly. Now, this particular quote of Babasaheb Ambedkar is actually quoted by the Supreme Court in many cases. Okay, I have just given the reference there. In the debates of the Constituent Assembly, Official Report, Volume 9, while moving to add new articles in 300A and 300B after Article 300, corresponding to Article 341, 342, Dr. Ambedkar explained as follows. The object of these two articles, okay, 341 and 342, scheduled caste and scheduled tribe, as I stated, was to eliminate the necessity of burdening the constitution with a long list of scheduled castes and scheduled tribes. It is now proposed that the president, in consultation with the governor or ruler of a state, should have the power to issue a general notification in the Gazette specifying all the castes thereof deemed to be scheduled caste and scheduled tribe for the purpose of the privileges which have been defined for them in the Constitution. The only limitation that has been imposed is this, that once a notification has been issued by the president, which undoubtedly he will be issuing in consultation with and on the advice of the government of each state. Thereafter, if any elimination was to be made from the list so notified, or any addition was to be made, that must be made by Parliament and not by the President. The object is to eliminate any kind of political factors having a play in the matter of the disturbance in the schedule so published by the President. Now, this paragraph is very, very important to understand. What in the in the interpretation that many of us have in the tribal collective, that in this paragraph, Babasaheb Ambedkar simply said, it is only the parliament actually has the right to basically identify who is a scheduled caste and who is not a scheduled caste, and who is a scheduled tribe and who is not a scheduled tribe. This arose in the light of the fact that there were basically debates that came telling Dr. Ambedkar, when Article 300 and 300B was being discussed, why don't you define and simply identify and then notify that this is a scheduled tribe? Why do you have to go through this whole very complex process? Gives the president the power to identify who's a scheduled tribe and need not go through this whole process. Dr. Ambedkar, as I said, and I have actually stressed on these lines, the object is to eliminate any kind of political factors having a play in the matter of the disturbance in the schedule so published by the president. Now, many people are a bit confused about this, but there was a very interesting explanation given by Santosh Hegde, interpretation of Babasaheb's point. And this comes in an article by K. Balagopal in 2005, published in EPW. It's called Justice for Dalits Among Dalits. Ambedkar's observation, noted Santosh Hegde, Article 341 in the Constituent Assembly debates, when a question was raised as to why the president who declares the list of SC/ST should not be given the power to add or delete communities from the list, and why that power should be given to the parliament, Ambedkar is supposed to have said that it was to eliminate any kind of political factors having a play in the matter of disturbance in the schedule so published by the president. That Ambedkar used the expression disturbance in this context is relied upon to draw the far-fetched inference that any disturbance and not merely addition or deletion of a community is included in the meaning of include or exclude in Article 341(2). Ambedkar was talking of something else. He evidently apprehended that the president may act as an instrument of the party in power in adding or deleting communities from the SC/ST list. Whereas, even if the party in power has a majority in the parliament, the very process of lawmaking, with its debate and discussion, would act as a check on malified politics. It is this problem that he was addressing, and not the issue whether adding or deleting communities from the list includes any and every disturbance. The Supreme Court has in recent times laid down the proposition that it is permissible to look into the Constituent Assembly debates to understand the meaning of the provisions of the Constitution. Now, that completes a very interesting kind of a discussion and a kind of a content that I presented, and much more in the light of the fact that, why is it that the Constitution says, right in the beginning during the Constituent Assembly debates, that it is the parliament that must finally decide. No one else is the authority. It is the parliament that is the final authority, both houses of parliament. So now let me just go a little bit now to, I will read this because it's available in public. It's not like a big thing, but I think in the light of the kind of discussion we're having as academics, it's very important to kind of look at what are the procedures and the process developed. Now, there were many processes and procedures even initially, but a clear process and procedure was institutionalized. The modalities were written down in 15/6/1999. And I've written down the reference. The Cabinet Committee on Scheduled Castes, Scheduled Tribe and Minorities, in its meeting held on 15/6/1999, had approved the following modalities, and Para F amended in its meeting held on 25/6/2002. So while the modalities was actually written down clearly in 1999, some amendment was made to Para F in 2002. Let me just have a little bit of water and I'll just. Now the modalities read like this, and I will go slow. Point number A, cases favored by both the state government and the Registrar General of India in their most recent reports would be referred to the National Commission for Scheduled Castes and Scheduled Tribe. Now, since 2004, we have only the National Commission of Scheduled Tribe. Because in 2004, the National Commission of Scheduled Caste, Scheduled Tribe was divided into Scheduled Caste and Scheduled Tribe as different. Scheduled Tribe is under Article 338A. Opinion. They would be forwarded to the Commission individually or in batches as may be practicable, along with the comments of the state government and the Registrar General of India, as well as any relevant material information furnished by them or by representation. Explanation a little bit. All demands for scheduled tribe status must go through the state government. It is the state government that must actually provide, a recommendation to the central government, and that too with provisions of what is understood as evidence and reports that is available in order to actually affirm this representation of being identified as a scheduled tribe by the state, by the government. State government is the starting point. But from the state government, when it goes to the central government, and the agency responsible for that is the Ministry of Tribal Affairs. The Ministry of Tribal Affairs will send to the Registrar General of India. And the Registrar General of India has their own roles and responsibilities on how to go about that process. Now I will read further. Some issues concern not one but several states. Example, the status of SC/ST migrants. These would also be referred to the National Commission if the RGI and majority of concerned states have supported the modification. Now, after the states and the Registrar General of India supports the recommendation of the state that has been sent to the Ministry of Tribal Affairs, it will be sent to the National Commission of Scheduled Tribes. If you look and try to understand what is the National Commission, National Commission of Scheduled Tribes is by law in Article 338, an article of the Constitution of India, was created to defend and safeguard the scheduled tribes of this country. The National Commission is a very powerful institution of governance, which was created by law, that actually looks to investigate and monitor all the safeguards that have been given by the Indian state to the tribal people in this country. It also looks at, it inquires into all kinds of complaints. Like if anybody has a complaint against anyone, it can be across. It can be reasons of education, reasons of employment, reasons of atrocity, reasons of humiliation, reasons of insults. Any tribal community who faces this, they have an institution of governance that they can go and complain. Okay, and that is the National Commission. And the National Commission is bound by law to inquire into these specific complaints. And other than that, the National Commission also looks into the implementation, okay, of the plans and the development projects to do with the socio-economic development of the tribal people, okay, the scheduled tribes, not tribal people, scheduled tribes. There's a very distinct difference between tribal people and scheduled tribes. So the National Commission looks into the development process of scheduled tribes. The National Commission is also responsible for presenting an annual report about what has happened regarding the safeguards, and this report has to be submitted to the president, who will then have to actually put it before the parliament. Okay, and then the National Commission makes recommendations to state for the implementation of certain things that probably has gone a little bit here and there in terms of the implementation process. National Commission monitors that. Okay, and it discharges such functions as regards the protection of welfare and the socio-economic development of the scheduled tribe. Now, this is very important. And the National Commission also has the authority to summon anybody, okay, any non-tribe, okay, who there is a complaint by the tribal community. National Commission have the authority to summon and enforcing an attendance of that person to the National Commission. Okay? National Commission receives affidavits. It can ask for requisition order from the courts. It has that authority. So before I go further, please note that the National Commission, as per the Constitution, is a very powerful body. And it is so powerful because it's the only organ that is institutionalized by the Constitution to protect and safeguard, to defend the rights of the scheduled tribes in this country. Now, point number C, it may be suggested to the Commission, the National Commission for Scheduled Tribe, that while examining the above cases that has been put forth before it, they should associate through panels or other means expert individuals, organizations and institutions in the field of anthropology, ethnography, and other social sciences, in addition to the state government reports for recommendation and the Registrar General of India and the Anthropological Survey of India on regional basis. Now, this is a very important point. The National Commission will look into the details of what report has been submitted for any claims to be made. That is anthropological, ethnographic, committees have to be set up, the evaluation of the state government recommendation, the RGI recommendation, and the Anthropological Survey of India. They may also consider holding public hearings in areas relevant to the claims under examination. So many people who are scheduled tribes, they can actually, request the National Commission to actually have public hearings if there is a protest against any of the so-called demands by other communities to be scheduled tribe. So that's the space that is given by the Constitution. These guidelines cannot be binding on the Commission, but may be suggested in the interest of fuller examination of the cases. Now, this was in 2002, but over a period of time, National Commission has become a key organ of the state by which many of these cases are being debated. Now, interestingly here, that is noted, the Commission would also be requested to give priority to cases in which the courts have given directives regarding decision within a stipulated time period. Now, this can be interpreted in various ways, but one of the things that have happened is that after these fake cases of scheduled tribe certificate being taken by many people who are not scheduled tribe, there were a lot of cases that went to court. And in that sense, these cases that went to court goes back to the National Commission a little bit. And then the court asked the National Commission to speed up the process, so that the court case can be worked out. Now, there are many other interpretations of this particular line that was stated in the 2002 modality guidelines. But in court, it is written, in such cases, extension of time would be sought from courts where necessary by the National Commission, citing these modalities for the determination of claims. Such cases would be separately processed and sent for earlier decision. Number C. Number D. Amending legislation would be proposed to the Cabinet in all cases in which the National Commission, the Registrar General of India, as well as the state governments have favored modification. Those cases with which the state government and the RGI are in agreement, but which the National Commission of Scheduled Tribes have not supported, would be rejected at the level of the Minister of Tribal Affairs at this point in time, earlier the Minister for Social Justice and Empowerment. Point number E. Claims for inclusion, exclusion, or other modifications that neither the Registrar General nor the concerned state government have supported would not be referred to the National Commission. These would be rejected at the level of the Minister for Social Justice and Empowerment or the Minister of Tribal Affairs now. Point number F. In case of claims recommended by the concerned state government union territory administration, but are not agreed to by the Registrar General of India, the concerned state government union territory would be asked to review and further justify their recommendations in the light of the comments of the RGI. On receipt of the further clarifications from the state government union territory, the proposal would be referred to the RGI for comment again. In such cases where the RGI does not agree to the point of view of the state government or union territory, on a second reference, the Government of India may consider rejection of the said proposal. Point number G. Claims in respect of which the comments of either the RGI or the state government or both are awaited would remain under consideration until their views are received. Thereafter, they would be dealt in accordance with modalities and point A and F. Number H. Claims recommended suo motu by the National Commission would be referred to the RGI and the state government. Depending on their responses, they would be disposed of in accordance with modalities D and F as may be applicable. Now, this was a note for the Cabinet Committee on Scheduled Castes, Scheduled Tribe and Minorities moved by the Ministry of Social Justice and Empowerment right? Their note number 12016/36/98 SCD-RL cell dated 17/12/1998 and noted updated in 12/1/2002. So this is the modality. This is how one have to go through when one demand the scheduled tribe status. Now, all the demands don't come from a single community. There are many communities that demand scheduled tribe status. They can come from the correction of names in the list. They can come from a new entry of a sub-tribe within the single entry in the list. Or they can come from a totally new community that has no relationship at all. Either matter what the case is, this is the process that one has to go through. Now, let me go to the last part of my presentation, which I think is a key point. I just want to mention this a little bit because I think there's a lot of debate now about a particular case that is being discussed. And I just want to, this judgment by the Supreme Court basically relates to all of the presentation that I made, but it's much more directly related to what is the process, the component number 3 of my presentation, and also a little bit about scheduled caste, scheduled tribe definition, and so on and so forth. Now, in one of the ruling, and this is a case of in the Supreme Court judgment of the state of Maharashtra versus Millen and others, 28 November 2000, the Supreme Court noted the laudable object of the said articles 341 for scheduled caste and 342 for tribes is to provide additional protection to the members of the scheduled caste and scheduled tribes having regard to social and educational backwardness from which they have been suffering since a considerable length of time. The words caste or tribes in the expression scheduled caste and scheduled tribes are not used in the ordinary sense of the term, but are used in the sense of the definition contained in Article 366(24) and 366(25). In this view, a caste is a scheduled caste or a tribe is a scheduled tribe only if they are included in the President's order issued under Article 341 and Article 342 for the purpose of the Constitution. Next point. It is only the Parliament that is competent to amend the orders issued under Article 341 and 342, as can be seen from the entries in the schedule pertaining to each state. Whenever one caste/tribe has another name, it is so mentioned in the brackets after it in the schedules. In this view, it serves no purpose to look at gazetters or glossaries for establishing that a particular caste or tribe is a scheduled caste or scheduled tribe for the purpose of the Constitution. Even though it is not specifically mentioned as such in the presidential order, orders once issued under Clause 1 of the said articles cannot be varied by subsequent order or notification even by the President except by the law made by Parliament. Hence, it is not possible to say that the state government or any other authority or courts or tribunal are vested with any power to modify or vary said orders. This is a Supreme Court judgment between the state of Maharashtra versus Millen and others on 28 number 2000. It says in an appeal 2294/1986, page number 5. Now, let me read this judgment a little bit because it gives us a little bit more of clarity what the Supreme Court basically has ordered on issues concerning scheduled tribe. Thus, it is clear, notes the Supreme Court, that states have no power to amend presidential order. Consequently, a party in power or the government of the day in a state is relieved from the pressure or burden of tinkering with the presidential order either to gain popularity or secure votes. Number of persons in order to gain advantage in securing admissions in educational institutions and employment in state services have been claiming as belonging to either the scheduled caste or scheduled tribes, depriving genuine and needed persons belonging to the scheduled caste and scheduled tribes covered by the presidential order, defeating and frustrating to a large extent the very object of protective discrimination given to such people based on their educational and social backwardness. Courts cannot and should not expand jurisdiction to deal with the question as to whether a particular caste, subcaste, a group, or part of a tribe or subtribe is included in any of the entries mentioned in the presidential orders issued under Article 341 and 342, particularly so when in Clause 2 of the said article, it is expressly stated that such orders cannot be amended or varied except by the law made by Parliament. The power to include or exclude, amend or alter presidential order is expressly and exclusively conferred on and vested with the Parliament, and that too by making a law in that regard. The president had the benefit of us consulting states through governors of states which had the means and machinery to find out and recommend as to whether a particular caste or tribe was to be included in the presidential order 341, 342. If the said orders are to be amended, it is the parliament that is in the better position to know, having means and machineries unlike courts, as to why a particular caste or tribe is to be included or excluded by the law to be made by parliament. Allowing the state governments or courts or other authorities or tribunals to hold inquiry as to whether a particular caste or tribe should be considered as one included in the schedule of the presidential order, when it is not so specifically included, may lead to problems. In order to gain advantage of reservation for the purpose of Article 15.4 and 16.4, several persons have been coming forward claiming to be covered by the presidential order issued under Article 341 and 342. This apart, when no other authority other than the parliament, that too by law alone, can amend the presidential orders. Neither the state government, nor the courts, nor tribunals, nor any authority can assume jurisdiction to hold inquiry and take evidence to declare that a caste or a tribe or a part of or a group within a caste or a tribe is included in presidential orders in one entry or the other, although they are not expressly and specifically included. A court cannot amend the said presidential orders for the very good reason that it has no power to do so within the meaning, content, and scope of Article 341 and 342. It is not possible to hold that either any inquiry is permissible or any evidence can be let in relation to a particular caste or tribe to say whether it is included within presidential order when it is not so expressly included. So I think that is you get a clarity about the process of what the courts have basically, and this is the reason, especially after 1977. So many court cases have come to the high courts and the Supreme Court, that the Supreme Court had to intervene from time to time. And I have noted the state of Maharashtra was million, but I have not gone into the details of, who's million and all of that. I think is needed at this point. My intention is only to clarify what the Supreme Court has said about these modalities and about who can define who's scheduled tribe, who's not scheduled tribe, what are the processes and procedures, what is this list all about. That's my intention. My intention is not to bring any case for the sake of academic discussion. That we can do some other time in the tribal collective. But at least here it is important to note very clearly, as the Supreme Court has laid down, how should we go about the whole process. Now, I will come to my last slide, and with this I will end, because I think I've spoken quite a bit. And my intention in this presentation is actually not to, I don't want to engage in, too much of interpretation or theorization or engage in any kind of a theoretical exercise, which I think many of us do all the time. But my intention is basically to kind of provide, from a historical point of view, a little bit more technical kind of a presentation that will help everybody in the tribal collective and those who are interested in such an issue to be informed about what exactly is the history about this debate taking place right now in the country. Now, I'll end by some thoughts of mine, and these are my observations. They have got nothing to do with anything else, but these observations also come from kind of data available in the field. Now, a lot of debates taking place about many communities demanding, and please note, across the country, there are 210 cases of demand for scheduled tribe status that are there in the parliament. Now, I will read out a report of the Rajiv Gandhi Institute for Contemporary Studies, which I think is a very important report, that came out in 2017. It writes like this. The Constitutional Amendment Scheduled Caste Scheduled Tribe Order Amendment Bill 2016 proposes to include 23 different communities of Assam, Tripura, Tamil Nadu, Chhattisgarh, and Jharkhand in the list of STs. Despite political consensus and approval of National Commission for the Scheduled Tribe and the previous government, the NDA government took more than 2.5 years to move this constitutional amendment bill. Currently, there are 210 proposals of different communities for the inclusion in the list of STs pending with central government for final approval. The bill attempts to solve only 12 out of 210 proposals seeking ST categorization. So you must know that, there are some communities that are demanding scheduled tribe status. You must know that there's not only one. There are 210 proposals that are pending with the central government at this point in time. And then some of them have already moved through the process like anything. They have gone through the Ministry of Tribal Affairs, they've gone through the RGI, they've gone through the National Commission, and they're pending with the central government. Now, the reason is simple that such a complex issue, it's like the Constitution has created such an, it has knitted it in such a particular manner, to unpack, to unravel some of these so-called structures that have been inbuilt over a period of time, starting from 1950. It's a little bit difficult, and one can only, uh, be humbled by these processes and feel a little bit pity and sorry for the central government to have to handle this very, very complex issue. If people think that demanding scheduled tribe status is a very simple process, they must know that it's such a complex process. It can open up things that you can't imagine in the light of the debate concerning the scheduled tribe 1950 list. Now, the second point which I want to mention is that it's taking place now. Among many communities demanding scheduled tribe status, the earlier intention of the government actually is clear, as I have kind of explained in the earlier part of my presentation, is that the scheduled tribe was seen as outside of the pale of dominant mainstream society, and the identification of scheduled tribe in relation to Article 341 scheduled castes, which have been mainstream, but mainstream on the structure of the practices of untouchability. The scheduled tribe was seen as outside, and this notion of integration and assimilation was a foundational principle that kind of defined many so-called interventions by the government in order to actually bring these communities inside, to bring these communities inside the mainstream society. That was, if you look at the Constituent Assembly debates, that's exactly how it is all about. How do you bring and mainstream them? How do you bring and include them? Now, so the tribes in that sense were not mainstream. They were outside of the mainstream. And mainstream larger society is identified by different social structures and social processes. Now, on the other hand, what is interesting to note is, as much as this intention was there, something very interesting is happening in the light of these 210 cases, and there are many more. Probably by 2017, we can add more names into what cases are pending and many communities demanding. Now, it looks as though there's some kind of a reverse mainstreamization. While the Constitution imagined that scheduled tribe should be mainstream into mainstream society, assimilated into mainstream society through the integration process, and all structures of governance and structures of the state and structure of government were actually laid for that purpose with that vision. Now, many people who are generally mainstream, they want to become tribes. Now, this is an interesting, from an academic point of view, it's interesting. Now the tribes have become the mainstream because many of those have come who are part of the mainstream. Now they want to be out of the mainstream. Now, there are many reasons for this. I don't want to problematize it. I just want to mention this point. Okay. And the reasons are because of power, political power. The reasons are because of, probably it can be educational seats, it can be jobs in the government, it can be political representation, which the Constitution allows the scheduled tribe to have. It can be related to land, it can be related to so many issues. It's a complex issue, but I just want to mention that it looks something like that. So not all communities demanding scheduled tribe actually want to be scheduled tribe. They are scheduled tribe because of many other reasons. There's no need for me to kind of problematize beyond a point, but it's just to mention that this is the case. And the third point which I want to mention here, which is I think important, is that there's a little bit more of a complex process has arisen after the bifurcation of the National Commission for Scheduled Caste, Scheduled Tribe in 2004 into the National Commission of Scheduled Caste and the National Commission of Scheduled Tribe. Now the kind of debates that I'm starting to see emerging out of the National Commission, for instance, is to develop a certain kind of criteria about the scheduled tribes that is, somewhat detached from its direct relation to the National Commission for Scheduled Castes or the scheduled caste category. Now, for many of us, as I said, 340, 41, and 42 has to be read together. Now, if 342 is to be read separately, and then criteria have to be created separately, then there will be a whole lot of different debates altogether. Okay? Now, it's a very complex process, but that's just needed to be noted at this point in time, not needed to be gone beyond a point, but this is just to make a point. Now, let me make one final point. I think many of us who have studied some of these processes, especially the Constitution, the Constituency Assembly debates, and many of us coming from the Tribal Intellectual Collective are very keen to kind of understand Jaipal Singh and Babasaheb, Dr. B.R. Ambedkar, and so on and so forth. If you look at that debate again, and this is a point I want to just keep you to think a little bit. I'm not making any interpretation that is conclusive in any way, but just for you to think. Jaipal Singh made a point. He said, why don't you identify as Adivasis? And Adivasis mean indigenous people. So why don't you identify indigenous people as scheduled tribe? I mean, what is this creation of a scheduled tribe? Why shouldn't Adivasis directly become scheduled tribe or indigenous become scheduled tribe? So Babasaheb Ambedkar's point was simple. He says that not all indigenous people are scheduled tribe. Okay, all scheduled tribes are indigenous people, but not all indigenous people in this country. And this country has indigenous people everywhere. All of us are indigenous people. Who is not indigenous to this land? Okay. So Babasaheb Ambedkar's position was very clear in response to Jaipal Singh. Yes, you are correct. There are indigenous people everywhere. But not all indigenous can be brought into the scheduled tribe category. However, the scheduled tribe, as he said and explained to Jaipal Singh, we think, because there's so many debates that are happening that basically looks at Babasaheb Ambedkar in a very negative light about his, contestation with Jaipal Singh. In today's gathering, I just want to make this particular point. You will have to understand this debate properly. Okay, we need not be very, very exclusive in the way we try to understand and interpret these processes. We have to understand it in the light of the debate that has taken place, and then from that particular process, pick up and try to interpret many of the things that are happening in the reality right now. There's so many complex processes, and it's unfortunate it's become such a volatile environment and so much reactivity everywhere. As member of the Tribal Intellectual Collective, we are academics. We are not politicians. We are not journalists. We're here to sit down to look at the nitty-gritty details of what it is all about. We're here to look at history. We're here to study the details of the minute processes that involves itself in what is understood called the scheduled tribe reality. We're here to understand the Constitution, the Supreme Court, and so on and so forth. And, I will leave with this point before I end to note that I feel that whatever has happened right now, the Constitution is something that, for the scheduled tribe, the Constitution is a real protector. I mean, I don't know how some of you would look at it, but for me, my reading of very detailed reading of these processes, the Constitution of India, is really a protector of scheduled tribe. So much so, the whole positive discrimination which the Supreme Court mentioned, and so much so that everything that the Indian state has done for the scheduled tribes, and this has to be noted, has actually really succeeded. I don't find a single scheduled tribe in this country who demands that we want to be part of India. Everybody wants to be part of India. And the reason we want to be part of India, and we want to claim India as an own, and we want to say that we are more Indians than many, is for the simple fact that the framers of the Constitution crafted the Constitution in such a manner as to bring us into the Indian state with the protective structure, with protective mechanisms, with this alternative, a little bit of a different administrative structure, allowing all of that. And in bringing us in, the success of the Indian state and the Indian Constitution is that you have one of the most loyal subjects and loyal citizens of the Indian state in the tribal people. I will end with these words. I think there's a lot more discussion we can have. This is just one of the first of the lecture series regarding this particular issue in the tribal collective. In the next time we meet again and we discuss more details, but next time I will just focus on one point, because even on one point, if you go into the details and the documents that we have collected, when the tribal collective has one of the largest archives that we have collected on tribes, and I'm very happy to share that anybody can access it if you want. But for another gathering and another lecture, we will take it there. On today's lecture, I'd like to thank Professor Khaka for giving me this opportunity to share these issues in the light of a very complex situation in the country. I would like to tell all the Tribal Intellectual Collective members that I'm very happy that you've come to participate in this discussion. We are a growing group of academics across the country talking about tribal issues, gaining expertise about our own reality, gaining expertise about the Indian state, about Indian culture, about caste society, about many other societies. And I'm also thankful to other friends who have come today. I do not really know the reason why. Probably this is a very debatable concept at this point in time, debatable issue. But I'm so glad that you've come. The tribal collective is an academic community. It does not, it doesn't engage in any kind of an activity to put someone down, to exclude the other down, and to get into these kind of very negative, reactive processes. And with that kind of a few lines, I'd like to end my presentation. Thank you, Professor Khaka, so much. And thank you all of those who have come. Thank you so much.
Thank you, Bodhi. Comprehensive, with history, with law, with commissions, various kinds of reports, assembly debate. So, I think it was very comprehensive, and I think it's an issue which was needed to be studied, which needed to be explored, and it's good that you have done it. And from my side, it's really congratulations on taking up this important area which has remained unexplored.